Legal insanity in the state of Texas is a very, very difficult defense to make successful in front of a jury. I was told last week at a conference that less than 0.1% of cases that incorporate insanity as a legal defense are successful. And this is for many reasons. And probably the most basic is that jurors, realizing that this individual committed this horrendous act for which he is being tried, is crazy, and if he gets out, there's no stopping him, and therefore jurors will tend to reject the opinions of the experts, reject the arguments of the defense counsel, and conclude the individual doesn't meet the insanity standard. The insanity standard in the state of Texas is very simple, unfortunately. It says that an individual must be suffering from a severe mental illness or mental defect, underscore severe. But not only must the person be suffering from that severe mental illness, but that mental illness must cause that person not to know what he or she is doing is wrong. Now, the courts have held, and the prosecutors stress, that this is a bifurcated standard, giving the prosecution the ability to stipulate that the person is severely mentally ill, however, not stipulating that the mental illness caused the person not to know what he or she is doing is wrong. My opinion is that rather than bifurcate the standard, there are certain types of mental illnesses that a person experiences, delusions, psychotic delusions, that basically is the unreal world in which that person lives and in which that person makes decisions. And obviously a decision as to the wrongfulness of a person's act, knowing that it was wrong or knowing that it was not wrong, is a decision-making process within that sick mindset of the individual on trial. I argued that to juries when I use the insanity defense, and I select juries in voir dire with questionnaires about that very issue. But all in all, the insanity defense is difficult, but not impossible to render one successful in court and in trial, and get that client of yours into a proper facility so that he or she can be properly mentally taken care of. We're not allowed to tell jurors, for instance, what the outcome of a insanity defense would be, leaving them with the obvious impression that Mr. Smith, who's being tried for double homicide, is able to get on the elevator if we acquit him by reason of insanity and ride down with us. That's not the case. We all know that if an individual is found not guilty by reason of insanity, for instance, of a first-degree felony, that person, if it's a violent offense, will be sent to North Texas State Hospital at Vernon, and which is a maximum security unit, and will stay at Vernon until that person is determined to be not a danger to others. Then that person can be transferred down to a minimum security mental health facility, but is still under the jurisdiction of the judge for the time that that individual would have received had that person been convicted outright. And each year, that person's case comes up for review. So we have safeguards within our system.